said, interviewing clients. So, clients are different than witnesses, right? Clients are a little bit different than witnesses. I say this all the time. You get to know your client a little bit better than you would a witness, unless you're using the same expert witness all the time. Then obviously you get to know that witness, because sometimes there's an expert witness out there that's really good in our trials. So we'll use that person all the time. And since we're using that person all the time, we get to know them. But, it's compensation too. We compensate them to help us out or show up on trial and all that stuff. Most of the time, you don't get to know witnesses that close. So clients is a little different. You're working with them all the time. You're expecting them to provide certain documentation for you. Remember, everything's on a deadline. So clients think, oh, 30 days, no big deal, right? You send them an email, we need this in 30 days. And trust me when I say this, 30 days goes by fast. Clients think, oh, I have plenty of time, and then you're sending reminder emails and they haven't even started. And it's like 30 days, right? And what if you have to get some kind of document you need, or, I don't know, medical records? It's like 30 days goes by really fast. So in order for you to make your client happy or comfortable and work with you as a team, it does take, sometimes it takes techniques depending on the client. Okay. So here we're going to first look at client interviews and then discuss witness interviews. So everything I talk about next is for the clients, okay? So the type of client interviews include the first one. I say this all the time. We always have the first initial interview where we actually meet our client. It could be on Zoom, it could be in person, it could be on the phone. It just depends what's happening in their lives and if they can meet us. But it's the initial interview. That is the first thing that starts. And that's the first time they meet you, okay? Usually at the initial interview, it's the attorney that's doing all the talking. It's the paralegal that's taking the notes. Now, that doesn't mean that you don't do research before the initial interview. Paralegal, you absolutely do research before the interview so that you know exactly what facts you need. You need to know, the facts a little bit so you can find a cause of action, okay? And then you're going to add to your notes. It's very important that you walk out of that interview feeling a little bit fulfilled, like, okay, I have enough facts, right, to start researching, to start verifying these facts and start to create a legal memo for the lead attorney, okay? And then if we don't, because, I don't know, something happens, subsequent interviews they're allowed. We don't want 3, 4, 5. It's like we're always bringing the client in, because we're forgetting to ask these, these really important questions. So that's why you want to have a checklist, okay? But you can have a subsequent interview. There's nothing wrong with that. To obtain further information, of course. Now, if you can do it through an email, maybe you just need 2 or 3 more facts, send them a question. Send them a questionnaire in the email, let them fill it out. It just saves you time, it saves them time. You can also have informational interviews if needed, or meetings to inform the client of the case's status and to prepare the client for various legal proceedings. Right here, to inform the client of their status on their case. That's a simple email. You don't have to have them come in for that. Even if it's a settlement agreement, the lead attorney will probably have you send them the settlement agreement. They can read it and agree to it or disagree to it. So it's just a simple email, I think, to inform them about their case. But just remember, when it comes to professional responsibility for the attorney, and when it comes to ethical obligations for you guys, the paralegals, you should always keep your clients, informed about their case. The California Bar is very big at that. They really, really want you to inform the client, even if it's not something you think is important. Doesn't matter. If something was, learned about the case, and it needs to be, at least keep them informed. This is what took place today. Maybe it doesn't matter to you, but it could to them. Okay. Now, does the attorney always do that? Most of the time. Most of the time, the attorneys will make their phone calls or their rounds, in all their cases, let people know what's going on, but not all the time. Sometimes you'll be CC'd in an email and it's stating what's going on with my case. When you get that email, your lead attorney has not been informing the client, okay? So just be aware of emails like that. You'll receive them. But prepare the client for various legal proceedings. Well, that's if we're going to have the client in court. If it actually makes it to court, we have to prepare them. It's a play. I tell you guys this all the time. We have to prepare our client, to take the stand, what questions we're going to ask, all that stuff. So you got to prepare the client for a lot of things. How to dress sometimes. Body language, when we get to that chapter, you'll see eye contact, body language, maintain your composure, you're going to be attacked by the opposing counsel. Credibility is going to be attacked. They're going to be, using leading questions and bringing you and scaring you and, all that good stuff. We just try to help our clients be composed and, prepared for all of that. No, we don't want anything to be shocking to them. Okay. All right. With that said, this is the very first interview. We call